Please rise. Justice of the Appellate Division, Supreme Court, first of all, all persons having business with the appellate division are here to be attended and shall be heard. Please be seated.
Good afternoon, all. Happy New Year to everyone. Hope you all had a wonderful break, celebrated the various holidays. We, of course, were reading your briefs during. Why are you laughing? Of course, we were reading your briefs during the short 2 weeks, so we are totally familiar with your arguments. To that end, let's start the new year off on the right foot, okay? So again, only ask for the time that you need in order to get out the salient points of your argument. Not the time that you would need in the real world, okay? But just what you need to get out the salient points of your argument. People v. Tyrell Bailey. Submitted. Matter of KL. Submitted. Juman versus Cape Church. Submitted. Sorry. Yes. Appellant?
7 minutes.
Any on rebuttal? Do you have a cross appeal? 6 and 2 and 4. Morales v. City of New York.
8 minutes and rebuttal.
625. Santana v. San Mateo Construction. Justice Gesmer is recused on that matter.
For the counts, Your Honors, may I request 4+1?
Respondent Con Edison, 3 minutes, please.
413. People v. Gilberto Castillo. That matter is submitted. Board of Managers versus Building 389 LLC. What remainder for reply? Yes, sir. 525. People v. Shakira wins. That matter is submitted. Bicoastal Properties versus Solomon.
Appellant requests 8 and 2.
Respondents request 8.
626. People v. Luke Ryant. That matter is submitted. Savesky versus New York State Division of Housing. That matter is submitted. Barbieri versus 175 West 12th Street Condo. 625. Gentile versus Juva Skin and Laser Center.
Appellant 5 and 2. Respondent 7.
525. New York NY 2015 boat versus 2435 Kingsland. 625. People v. Joan Perez. That matter is submitted. Efron versus Efron. I'm sorry?
5 and 2. Respondent 2.
522. Lopez v. Trahan. That matter is submitted. First case for argument is, I don't know. Juman versus Cape Church. Whenever you're ready.
Good morning, Your Honors. My name is Brian Gallagher.
Yeah, it's afternoon, but okay.
I represent 30 Warren Street LLC. It is a single-purpose, single-member entity which was created for the sole purpose of owning a single apartment in 30 Warren Street, the building, on the 4th floor. It was purchased on September 10th, 2020, which is admitted in deeds and otherwise, and it's admitted by us. The accident occurred 3 months earlier, apparently.
So you're appealing the trial court's denial of your motion for summary judgment, is that correct?
That's correct, Your Honor.
Okay.
Yes.
And so why was the trial court, or the motion court, excuse me, why did it err err in dismissing, excuse me, in not granting your motion for summary judgment?
Well, Your Honor, the main reason is most of the substantive factual statements and arguments we made were not opposed. But more importantly, the single thing that was presented on opposition to the summary judgment motion was an attorney's affirmation, which simply said we need more discovery. And in light of all the admissions we have already about the existence, I understand the reluctance because plaintiffs are concerned about, they're releasing a party, but we tried very hard to get this released, and we're forced to make the motion for summary judgment. And the reason really is, quite frankly, is my client, he doesn't have insurance on the apartment because he didn't own it at the time of the alleged accident, so he's coming out of pocket. So we moved quickly to try to get it resolved. But the response that was provided by for the opposition by plaintiff is skeletal. It doesn't meet the requirements of 3212F. At best, it's mere speculation and hope, which is exactly the kind of thing that is not that should not allow for a denial of the motion.
Okay, so the apartment in question was purchased by your client, that's 4C, apartment 4C?
4C, yes.
And that apartment was purchased on September 10, 2020, is that correct?
That is correct, Your
Do
Honor.
we know exactly where the incident occurred, what apartment or where in the building the incident occurred?
Yeah, we know that it happened on June 18, 2020, and that it happened on the 12th floor.
On the 12th floor. And what date?
It was on June 18, 2020.
2020. And again, your clients purchased apartment 4C September 10, 2020, is that correct? And is there any dispute or is there any issue as to whether that did in fact occur?
No, I don't believe there's any. It's in the verified bill of particulars and admissions from both sides. So no, I don't think there's any dispute about those basic facts.
Did they question the fact that it wasn't certified, although there was an ACRIS printout that verified that it was purchased in September, and of course you had the deed, but was it an evidentiary issue that derailed this?
No, Your Honor, they did not raise that as an issue below. I think they did raise it in the appellate brief, but it was not raised below.
And in fact, it's my understanding, did they ever respond to your demand for a bill of particulars as to the
They did
location?
not, and they're admitted by.
And they didn't even respond to your notice to admit, right?
That's correct. So, Your Honor, I would request, Your Honors, I would request that this court respectfully reverse the lower court, grant summary judgment to my client, dismissing the complaint with prejudice and all related cross.
Thank you.
Thank you very much.
Good afternoon, Happy New Year, Your Honors.
Same to you, thank you.
The main issue here is that this motion was premature. There's been,
Counsel, how did you respond to appellant's argument that that his client didn't buy the property until several months after this accident occurred?
yes, so that's what he alleges. We have not had a chance to depose that witness to
Did
actually
you do an
confirm that.
ACRIS investigation and find out who the prior owner was or anything else?
So according to our client, he observed people from 30 Warren at this property when he was working there. As far as whether they were performing construction or whether they own the property, that's what he told us when we did the intake of him. There's been no one that's admitted ownership of this property on the date of the accident in any of the answers.
One
None of the
second.
defendants have.
I'm sorry to cut you off, but you're confusing me. My understanding is that Cape Church, in their own admissions on this record, said that they own the premises, the building. We're talking about 4C. 30 Warren LLC is the condominium owner of one unit in this big building. And you keep saying property, property, and we know on this record there's a claim that the plaintiff had the accident on the 12th floor. So let's assume for your purposes that 30 Warren was somehow involved with reconstruction on his unit, because that's all he would be concerned about.
On the 4th floor.
On the 4th floor. Where is this issue? How could discovery possibly help you on this record when it's been verified that they bought it in September, 3 months after the accident?
That's the information that they're providing. I mean, we have not had a chance to cross-examine that witness to actually confirm if there was
But how do you
anything
get
else.
around the 12th, this discrepancy between the 12th floor and the 4th floor?
Yeah, no, certainly I understand that they're saying that they only own a property on the fourth floor. They haven't said anything about whether or not they had any involvement on the 12th floor. We haven't heard from any witnesses. We haven't had any depositions in the case to find out what their involvement was, if any, whether it was for construction on the 12th floor or any ownership of another unit.
Yeah, but Mr. Rafa's affidavit, which he put in support of their motion, I live in Utah. I want a place to stay in New York when I'm visiting New York. And he had the supporting documents with the purchase, the deed, and you had nothing to counter that affidavit of someone with personal knowledge about his own purchase, except to say, we need more discovery. You think that's enough on summary judgment?
So your argument is that although in his affidavit he stated that he purchased the apartment 4C, he did not state that he purchased any unit on the 12th floor where the incident occurred, and so therefore there should be discovery to question him as to whether or not, in addition to the unit on the 4th floor, he also purchased a unit on the 12th floor?
There needs to be discovery on not only ownership, but also on whether or not he was involved in any construction.
And this is again, disregarding the fact that Cape Church stated that they own the premises, meaning the entire building.
That's in their answers to a notice to admit they say that, but in Cape Church's answer that they submitted in this case, they don't say that they owned it. They in fact denied ownership on the date of the accident, which was 2020.
So the notice to admit in your mind has no relevance to whether they owned it or not?
Well, the issue is now we have a conflict in the evidence, which would require depositions, which is why I think it is.
You have a conflict perhaps as to Cape Church. You don't have a conflict as to the appellants here.
The issue as to the appellant here, 30 Warren, is that all we have is this self-serving affidavit from them. That's all we have. We don't have an ability
You also have
to
the
question.
deed. You're forgetting the deed.
We have the deed as well,
That's
but
much more significant than, well, I mean, every affidavit is self-serving, but in addition to the affidavit, it's supported clearly by the deed, right?
I would just wrap up by saying that that is just as to 4C. That doesn't tell us any of their involvement as to the 12th floor where the accident happened. There's a question of fact, there at least needs to be deposition so we could find out from all of the parties involved before this is reheard.
So you didn't get anything in terms of the owners of the various apartments in units in the building?
No, there hasn't been any discovery in the case yet other than myself exchanging the bill of particulars.
Thank you.
Thank you.
So, counsel, your client did not state that he or they did not own any of the units own any of the units on the 12th floor.
No, he did say in his affidavit that the only thing they owned in that building, was 4C. That's very clear. Listen, frankly, the only reason we're in this case is because, unfortunately, my client named his LLC the address of the building. And I understand why that may be some mistake here, but at this point, where all the evidence establishes my client had nothing to do with this. As far as the 12th floor, as far as I know, they haven't sued anybody who has an apartment on the 12th floor even. So, I mean, by logic...
Well, that's why they state they need additional discovery to see who, in fact, owns the units on the 12th floor.
And you know, they can do that, I guess, but I don't know at what point, the statute runs, but the bottom line for us is we own nothing on the 12th floor. We put that in evidence.
Well, you
we
didn't
do a
state
title
that...
search to figure out what's on the 12th floor.
But you really didn't state that in the affidavit. I mean, the affidavit says only, if I'm not mistaken, it says only 4C.
That's correct.
Does not say, and no other units in the building, specifically 12th floor.
Well, it's interesting, Your Honor. In the notice to admit that we served on Cape Church, we did ask them that question, and we say, did 30 Warren LLC own any other apartments, any other thing in the building, have any connection with the building other than 4C? And they admit, the owner of the building admits no. So the party that would know, the owner, would know whether we had any apartment other than 4C. That's what we've alleged. If the base, this is, it's interesting because this is exactly surmised guesswork. We've laid out, factual basis, I believe, Your Honor, for dismissal, and we've been dragged through this process. I believe unnecessarily, and my client spent a lot of money trying to defend it in the hopes that it would go away. But I think all the facts line up correctly, that we're just the wrong party here, and the reason we're a party is because of our name.
Thank you both. Morales v. City of New York. Yes.
Good afternoon, Your Honors. When a lower court creates new elements for an otherwise known doctrine of law special duty, and then embarks on a fact-finding mission regarding...
What new factors were created by the trial court, by the motion court?
I'm sorry, Your Honor.
What new, you said when a lower court creates new factors or something of that nature, what new factors were created by the motion court?
In addition to the otherwise known 4 elements for special duty, the lower court added the element that other available avenues of protection must be identified by the plaintiff, and additionally, that they must derive, those other avenues of protection must be derived from a source other than the defendant municipality. And that's not the 4-prong test laid out in Appellate.
Okay, well, but let's focus on the 4-prong test in Applewhite. How have you, well, rather, how did the defendant not meet their burden for summary judgment? How did the defendant not meet their burden for summary judgment underneath those 4 elements those 4 elements for special duty? That's what we're talking about here, right?
I'm having a little trouble hearing you, Your Honor. I'm so sorry.
How did the defendant not meet their burden for summary judgment dealing with the 4 elements for special duty? It was the defendant's motion for summary judgment?
The defendant moved for summary judgment, correct.
Did they meet their burden prima
He
facie?
overcame whatever burden had to be met by the defendant. That's not the issue that's up for appeal, Your Honor.
I think
They have
that might
not
be
met
an
their-
issue
their
that you need
secondary
to, I
burden
think
for-
it might be an issue that you need to address, though.
I'm sorry?
I think it might be an issue that you need to address. I think that one of the things that, in terms of any promise or justifiable reliance, I think that you might want to focus your argument today there.
Very well. I'll get right to that, Your Honor. When the firefighters appeared at Ms. Morales' apartment on January 7th, 2019, being fully aware that Ms. Morales had complaints of chest pains and shortness of breath, they administered oxygen, they took her pulse, they knew that she was at risk, they knew aid must be rendered to prevent
When they
harm.
received the 911 phone call, were they aware that there was a cardiac event
Yes,
taking
they
place?
were. Everybody testified that that information gets relayed by dispatch and is actually presented on a monitor before them, and all of the complaints are visible to the responding fire department members. And they were fully aware that there was complaints.
All of them testified, didn't they, that their obligation is not to rely just on what's relayed to them in the 911 call, but to do their own investigation, and therefore they took her pulse and counted respirations and checked her skin and so on, and reached their own conclusions based on what they saw in front of them, right?
They testified that that's what they did, and they're
And
trying
didn't
to...
they also testify that that's what they were required to do?
No, they testified, the testimony is also, it's an issue of fact, the testimony is also that if there's known chest pains and if there's known shortness of breath, that's a cardiac condition. They testified they're not doctors. That's the firefighters' own words. They're not doctors. They can't render an opinion, a medical opinion, as to whether or not shortness of breath and chest pains is indeed a cardiac event or
They
not.
got there and they didn't observe any shortness of breath while they were examining Ms. Morales, correct?
Well, they administered oxygen, Your Honor, so...
It doesn't mean
But they answered in administering oxygen based on their testimony, at least one of the firefighters, that it was designed to calm her down because she was anxious. She had communicated to her son that she woke up with a nightmare and that she was a little stressed and felt she should be checked out. Is that on the record, sir?
In addition to other versions
That's
of the
correct.
facts.
And there's also, when the son attempted to call 911 and said shortness of breath, she actually corrected him and said, no, I don't have shortness of breath, I have chest pain.
Your Honor,
But going back to what my colleague asked you, of the 4 Cuffey element, or the 4 elements of special duty. 1 in 4 appear to be implicated here. 1, what was the promise that the firefighters made as first responders to Ms. Morales that she relied on to her detriment in walking down the stairs?
They informed her, you can walk down the stairs. That is in the record. That's what the Sun said, and I'll direct you to the page where that is in the record, Your Honor. They told Ms. Morales, you can walk down the stairs.
Didn't the record
That's
show
in the
that they
record.
asked her if she could walk down the stairs?
What's that?
Didn't the record show that they asked her if she could walk down the stairs?
That's one version of the facts. The firefighters say that they asked her that. The Sun said they told her, you can walk down the steps. That's in his deposition. That's his words. And that's what she relied on. The firefighters took her pulse, gave her oxygen, and said, you can walk down the steps. And that's why she walked down the steps, because they told her to. Regarding the Sun and his comment on shortness of breath, Your Honor, there is nothing in the record that indicates that was a lie or that the mother corrected him. The mother never said, no, I don't have shortness of breath. That's a leap that the lower court took. The Sun said, my mom has shortness of breath and has chest pains. And she said, I have chest pains, I have chest pains. And he said, I told them that because I wanted them to come quicker. That's not an indication that he lied. The same way he said she has shortness of breath, she has chest pains, he wants them to arrive. That's the testimony.
Let's assume there's a
Determine that
triable
as a
issue of
fabrication.
fact.
I'm sorry?
Let's assume there's a triable issue of fact with respect to whether a special duty was formed. Does a triable issue of fact exist as to the applicability of the governmental function defense?
In regards to whether or not a special duty exists,
No. Not a special duty. We have duty, and then if there's a duty, then the government, municipality, bless you, can assert governmental function immunity as a defense, right? And there it boils down to whether the municipality, the actors within the municipality were exercising discretion in the manner in which they behaved.
well, in this case, Your Honor, it is an issue of fact whether it was ministerial or whether it was discretionary. And there's an opinion that's before the court from a expert first responder, an expert named Werfel, that suggests in no way, shape, or form is it ministerial, is it discretionary. It's entirely
that
ministerial to
affidavit.
take the stair chair.
That Werfel affidavit, were there specific references to specific protocols or standards, or was it general?
Not only by the expert was it specific, but by everybody that testified.
Could you show
Where
me
in
one,
the
a single, can you
EMTs
show
all
me,
testified that a
can you
stair
show me
chair-
a single place in his affidavit where he references a specific protocol by related, I mean, although the firefighters all testified that when they were trained, they were given manuals. Is there any citation by this expert to any of these, to a specific section of any of the manuals by which they were trained?
There is nothing within the manuals, however, they each
And there's
specify
nothing
they
in
were
his,
trained on
excuse
it,
me,
Your
there's
Honor.
nothing in his report, correct? In his affidavit attaching his claims to a specific protocol, a specific policy, correct?
Each of the firefighters testified that protocol in a cardiac event
Okay, that wasn't-
requires
you're
the
not
use of a
answering my
stair
question.
chair. They each
My
said
que-
that's that.
Counsel?
Yes.
You have to wait for the question to be asked.
Sorry.
The question is, in the expert's affidavit, does the expert point to any protocol in the manuals, et cetera, training, which state what exactly is to occur when when they find an individual experiencing the discomfort or whatever that the
No,
chief
he
was?
does not, but it is not required because each of the witnesses themselves testified that the protocol, that the ministerial duty of a first responder to somebody in a cardiac event requires the use of a stair chair and never walk them down. Everybody testified to that, including the firefighter witnesses themselves. But what they said is, when we got here, we decided it's not a cardiac event. That's what they're saying. They're all saying, had it been a cardiac event, we should have used a stair chair. But they're
But
saying
so
we
they're-
got there, we took their pulse,
So
and it
they're
wasn't.
making their determination of how to proceed based on right or wrong their evaluation of the decedent. So right or wrong, they evaluated the decedent as not presenting with cardiac event type symptoms, and based on that, they make a decision to allow her to walk down the stairs.
Well, it's an issue of fact whether or not they did that or whether or not it's Monday morning quarterbacking to protect themselves. Because they also had complaints of chest pains as they were telling her, you're not having a heart attack. She keeps saying, my chest is hurting, and they administered oxygen to her. So that could be, very well be something they're saying today to protect themselves from what happened the day before.
Counsel, you
Yes.
said something in response to my colleague that I don't think is borne out in the record. My understanding from the record is that when the 911 call went out, the dispatcher could not get either a BLS or an ALS ambulance to answer the call. So that, just bear with me for a second. So that the engine 88, I don't know if I'm using the right terminology.
It is.
Okay, showed up. And my understanding from this record is that firefighters, when they show up, do not have stair chairs with their trucks. They have to call for an ambulance who does have that equipment with their ambulances. So you recognize that they showed up knowing that they didn't have a stair chair, correct?
The stair chair was there before they had to walk her down the steps, and they knew that.
But they didn't, but the fire trucks don't have stair chairs.
They
You're saying
don't,
that
but
the
they-
other,
they-
the ambulance that had the stair chair was downstairs?
was present before, when they had her walk down the steps, and they knew it. They knew there was a stair chair down the stairs. The engine got there first 2 minutes ahead of time.
Is that in the record that
But
it was?
not because they were searching for
Is it in the
ALS.
record that there was only a 2-minute delay?
Yes. Yes, that's in the record, that they got there 2 minutes later and that they were down there. And it's also in the record that the firefighters knew the stair chair was
Well,
down
then
there.
why did the firefighters state that they walked her down because it would be faster to get her downstairs by walking her down as opposed to waiting for the stair chair to come up? It would be faster to walk her down in order to get to the ambulance.
Well, if they want to stick to that, that's an indication.
Well, not a
that-
sticking, I'm just saying that this is what they testified to, because they said it would be faster. I don't know if they actually used the word courtesy, but, you know, it was to assist her in getting to the hospital faster.
which contradicts them saying that she was not having a cardiac event. So, which is further proof that they knew she was having a cardiac event. If they want to get her down quickly, as they say, the right way to do it is safely and not to increase her demand for oxygen and to use the stair chair, which is right downstairs.
So, counsel, just to
They
back
have
up
to make up their mind.
To back up for a second, the first prong, right? For the first prong, you have to show that there was evidence of specific assurance by the firefighters.
And there
So
was.
what evidence of a specific assurance by the firefighters that she would not sustain cardiac arrest if she walked down the stairs?
My understanding, Your Honor, is that the first prong is to show that they assumed an affirmative duty to act on behalf of the injured party, and that they clearly did by arriving and rendering aid and taking a history. So
So you're saying that every time they show up and give any assistance of any kind, they assume a special duty to the patient?
No, if there's more, they assume an affirmative duty to act if they meet the first prong.
How
By
do-
showing up and taking action, they meeting the first prong.
So you're saying that they
The first,
They
there's
meet
three
the
more
first
prongs.
prong just by showing up and giving her any assistance.
That's not
Excuse me.
special.
Could you let me finish my question,
Yes.
please? Are you saying that they meet the first prong just by showing up and giving her any form of assistance?
By acting on behalf of the injured party. If
No,
they
that's
show up and
not.
they act on her behalf.
That's not what the cases say. There has to be a specific assurance by the firefighters. So where in the record was there a specific assurance by the firefighters to your client?
What they informed her, I think we're talking about prong 3, is that they communicate directly with her.
I'm talking about prong
Is it your
one.
position that they said to her, oh, you could walk? Is that the specific promise?
100%, if they say to somebody who thinks she's having a heart attack and complaining of chest pains, according to the fire department, if they say, can you walk down the steps? According to the son, they clearly say, you can walk down the steps.
It's, oh, you could walk, I think is what the son Hector said. Oh, you could walk is, I thought, what Hector said. But again,
but
how
even
does that translate to some type of promise that she is not going to sustain a cardiac episode by walking down the stairs?
Because she's looking to them for help and rescue, and they're the first responders who she relies on.
But
And
that's
when they
good, but then,
indicate
but
to her she
counsel,
can walk,
counsel, that's making it very broad, right? Because anytime a first responder responds, I mean, this is what they do, that we can't imply that there's some kind of specific promise made. I mean, they're there to do their job. So we need something, as the case law requires, something that is through promise or actions and affirmative duty. It's something that goes beyond just them being first responders.
Exactly. They have to be first responders that take action, and they took action. It's not disputed. They rendered oxygen. They took her pulse, and they asked her if she could walk. They wanted to get her downstairs quickly. They knew there was a stair chair downstairs, and they tell her, you can walk. And she relies on that and trusts them and walks and has a heart attack when she gets to the bottom because they increase her.
She doesn't have a heart attack when she gets to the bottom.
A minute after.
She actually goes into the ambulance, they administer care to her, and then she goes into cardiac arrest.
No, she was transferred to the EMTs on the sidewalk, and engine 88 left, and it was between the transfer and being placed in the ambulance that she has the heart attack.
But the initial assessment by the paramedics that were downstairs with the stair chair, based on the documentation in the record, that everything was normal.
Right. It's not like she walked down the it's not as if she walked down the 5 flights of stairs, exited the building, and then collapsed.
It is.
No, that's not what the record says.
Climbs into the ambulance and then has the heart
And they
attack.
administer care and they start administering care to her at that point in time.
I thought the EMT's testimony was that he performed evaluations. She had normal skin, other indications that her cardiac levels were normal. They testified that to that specific.
Right. The lack of clamminess of her skin, she appeared to be okay at that point in time. There was nothing.
The firefighters or the EMT?
EMT.
Two of them, then there are 2 EMTs who describe other conditions, but she enters the heart attack. It's 30 seconds from exiting the building. She has a cardiac event.
I didn't see anything about 30 seconds. But, Counsel, you have
can
time
look
on
at the sprint.
You do have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Your questions to Appellant's counsel demonstrate that you thoroughly know the record and the legal principles.
It also demonstrates that we think that there might be problems here, counsel. I mean, I don't understand how if the fire department shows up and there's questions of fact as to whether or not they were informed of the cardiac event or not. If there are questions of fact on that, I don't know how you meet your burden for summary judgment. But then to have someone who's experienced in such an event walk down 5 flights of stairs, someone who is obese, someone who's saying that they have heart problems, someone
and had a stent. The son, told the firefighters that she had a stent.
Well, the firefighters' assessment was based on their own observation of her. And they are obviously finding normal vital signs and that she is not in distress. The main problem that arises with a special duty claim here is, as the court pointed out, whether there was an affirmative assurance of safety. In a common law negligence case, you might find that there would be an issue of fact on these facts about what they knew and what she said to them. However, to establish a special duty, it is not, as appellant has argued, it is not just that the person receives care from first responders, because otherwise that would the exception would swallow the rule. At most, the only thing that we know is said is that supposedly Hector hears a firefighter say, "Oh, you could walk," but that's consistent with their testimony. That's actually consistent with their testimony that they gave her the option to walk. And it also in the record is the fact that she had previously.
I'm sorry, where in the record did it say that they gave her the option to walk? Because I know that they testified, hold on.
Oh.
I know that they said that they received notification, I think this was Clet who said that the bus was downstairs while they were still upstairs. They received a notification that happened. But where does it say, and maybe you can just point me to the page on the record, that they said, well, there's a stair chair that they have downstairs. You can wait for that to come up. Can you just tell me what page in the record so I could read it?
Well, they're saying, I don't have the page number in front of me, but Rudnick and the other firefighters testified specifically that they knew that they were giving her a choice, and that she could wait for the paramedics or that she could walk down.
So could you, I'm sorry.
There's nothing in the record that states that. In fact, there's nothing in the record that she even knew, that she or her son knew that there was a stair chair available that could be brought up.
That, again, Your Honor, is a question of negligence and not a question of whether there was an affirmative assurance of safety.
Well, you were the one who just argued that she was given the option, that she had the option. So how do you have an option to wait for a stair chair if you do not know that a stair chair is available and is readily available, that is downstairs right at that moment? That's what I don't understand. You were the one who brought up the issue of the option.
But saying you could walk, which is the only thing we know that was said, was not an assurance that she could, that it was, first of all, not an instruction. Appellant alleges, and the expert also claims that the firefighters had her walk downstairs. So disposing of that, when you say, oh, you could walk, it is consistent with giving her the option to walk and not saying you have to walk. And
Let's assume there's a sufficient ambiguity in the record that there's a tribal issue of fact as to the existence of a special duty. Why doesn't Mr. Warfel's affidavit, particularly paragraph 15 of that affidavit, raise an issue of fact on the governmental immunity defense?
The reason is that he attests that a first responder, such as a firefighter in this situation, will routinely check the person's vital signs. And they do, and they do that routinely. The question is what discretionary decision did they make that was that she could walk downstairs or not?
So, counsel, go ahead.
That is the discretionary decision that means that the governmental immunity, that even if there were an issue as to special duty, that the governmental function immunity.
So if they arrive there and she's in a cardiac event and they make the discretionary the decision that you can walk down the stairs with being fully aware that she's in a cardiac event, that's immunity no matter what.
Well, that, first of all, is not what the record says. Their testimony demonstrates that they were not aware that there was a cardiac event.
Or is there a question of fact about that based upon the 911 call and the testimony of the son?
Well, the testimony of the firefighters is that the 911 call that they get does not necessarily reflect what they're going to see on the scene. The son...
well, it doesn't necessarily reflect, but it does give you an idea as to the condition of the individual.
But the question you're asking...
And then that, again, as my colleague stated, that coupled with the statements by the son in terms of her condition, in terms of the stent. Also, apparently, she was obese, which was another issue.
But that may be a question of negligence, Your Honor. That is not a question of... And as Court of Appeals, not only in Valdez, but in the McLean case in 12 New York 3rd, indicated that discretionary decisions are not a basis for liability, for the municipal liability.
Counsel, your opposing counsel says that the firefighters were bound as a matter of that the firefighters' action was ministerial because they knew what they should do if there was indication of a cardiac problem, and therefore that their actions were ministerial, not discretionary. Could you address that?
Well, that's what I'm trying to address, Your Honor. The thing that is ministerial, arguably, or maybe not, but let's assume based on Werfel's affidavit, that making an assessment and checking the vital signs of the patient is something that a first responder would do. Then the question is, what determination do you make based on the information? It's just like in a police department situation, based on information that you have when you arrest a person or you don't, that's a discretionary determination. So assuming that Werfel is correct, the most that he says really is that he disagrees with the decision. He thinks it's negligent, but it is discretionary. And if they unfortunately misjudged her condition, there's no evidence that they knew that she was having a cardiac event based on their assessment of her. After all, if you have a stent implanted, you're not supposed to walk up and down stairs for a few days, but the idea is that you will live your life after that. And so there's no reason to assume, based on having a stent, that she can't walk downstairs.
Counsel, is there anything in the record, expert and other, that would suggest that when a call is in for a cardiac event, that they must wait for a stair chair to take the patient to an ambulance?
Well, the testimony of the firefighters and also the experts claim is that if you know there's cardiac problems, then you would wait for the stair chair. Now, of course, the expert...
No, but my point is that there's no rule about that.
No, there's no
protocol.
rule. No, there's no rule that's cited, but they acknowledge...
That's the point, because if there was a rule like that, that would make it ministerial, correct?
Yes, if there was a rule, but what they said was, the expert, for instance, says that the firefighters confirmed that she had a cardiac condition. There's nothing in the record to support that.
But the firefighters did state that if they knew that she was...
If they had known.
If they had known, they would not have walked her down the stairs, and they would have waited for the stair chair.
Right.
And then, why isn't that a credibility issue? Because we have certain evidence that says that the 911 phone call indicated a cardiac event. She has a stent, right? And then there's their testimony that says, well, we don't know, we don't remember, we think that we did this, but if we had known she had a cardiac issue, we wouldn't have walked her down the stairs. Why isn't that a credibility issue?
The document that refutes that, the PCRs refute that, because as the court noted in prior questioning, that the paramedics found her in normal condition when they received her at the bottom of the stairs and they took her into the ambulance and did their initial assessment. So they did not have, she wanted to be checked out for chest pains, but they did not have an indication of an imminent cardiac arrest at that time. There was nothing that would have made them know, and that's page 495.
Because it's not ministerial.
Well,
Whether or not someone is having a cardiac event is not ministerial.
Well, right. Well, right, because it's your determination based on your examination.
Right.
So that each of those components that go into what you find when you examine the person indicated that she was not having a cardiac event. Because remember, the 911 call is not for a heart attack. The 911 call is for chest pains, which you would have if you had a cardiac event, but it does not say that there's a cardiac event, so that doesn't even tell them that. There is, and then when they get there, they do not have an indication that she's actually having a cardiac event. So the fact that they make a discretionary determination. Now, let's assume that they missed something, which we contest. We wouldn't agree with that, but let's assume they missed something. that would be a negligence case if it wasn't for the doctrines of special duty and governmental function immunity. There could be an issue as to negligence in such a case. But with regard to the city's liability, where the city's liability has to be limited in order for the city to be able to provide these functions, there is no issue of fact here in this kind of case. Does the court have any further questions? Thank you for your attention, Your Honors.
Thank you.
The city can't circumvent the special duty doctrine by now claiming that a cardiac event was not occurring because that was the decision of the firefighters when they arrived.
I don't see that the special duty doctrine only comes into play if the action by the city actors is ministerial. But, so we never get to that if the firefighters are exercising their discretion in deciding whether or not she was having a cardiac event. So that's why it's not circumventing it, it's just the prior step is this discretionary or ministerial? And there plaintiff hasn't, you haven't put forward anything which says that if the 9/11 call says that the person making the call, or on behalf of whom the call is being made, is having chest pains and shortness of breath, that the firefighters have to conclude that that's cardiac arrest and have to act accordingly, even if their own investigation and examination of her indicates that she's not having a cardiac event. So are you claiming that there's such a rule?
If it plays out that way, I'm not sure, Your Honor, but I will say Respondent City admitted that protocol requires, had the firefighters known it was a cardiac event, use a stair chair.
No, but only if there's a finding that, but if their own inspection and examination of the person indicates that it's not a cardiac event, are they still required to do that?
If they're telling the truth, but their actions indicate otherwise. Their actions indicate they knew there was a cardiac event. They placed her on oxygen. The young son was, as they were walking mom down the stairs after they told her she can walk, the son says, wait a minute, I'm going to get her stent card. She has a stent. They're saying, how are you? She's saying, my chest still hurts. If you choose to believe them that she wasn't having a cardiac event, maybe, but I'm entitled for the evidence to be viewed in the light most favorable to Ms. Morales. And that light seems to indicate that indeed she was having a cardiac event and they were aware of it.
Okay, and so how though does that still overcome the governmental immunity defense?
Very well, because Respondent City just testified that if she's having a cardiac event, protocol is use the stair chair. Every witness, it's not written in a rule, but it doesn't have to be for it to be ministerial if everybody agrees that that's the protocol.
But all of the subjective tests indicate that she's not having a cardiac episode.
No, they took a pulse. It's all they did. My expert opines that's not what you do. They took a pulse and based on that said she's not having a cardiac.
That's not all they did. They also counted her respirations. They examined her skin to see if it was clammy, to determine if she was hot.
They said that, but when cross-examined at the deposition, they can't give any indication of what it was about her respiration, whether the breathing was rapid, lack of rapid, if they made any notes, if they documented indeed what it was.
Sir, I'm confused. Are you talking about the firefighters upstairs or the EMTs downstairs?
Upstairs firefighters. All they did was take a pulse and put her on oxygen.
Right,
And
I
tell her she could
understand
walk
that.
downstairs.
But then we have on the record the call report by the ambulance EMTs who do their own assessment as paramedics walking through the checklist, and everything appeared normal, and then there was the event. You disagree with that?
I don't remember offhand, Your Honors.
Thank you. Thank you very
Thank you
much.
very
Thank you
much.
both. The next matter is Santana v. San Mateo Construction. Again, Justice Gesmer is recused. Under the rules of the court, if there is a tie, another judge will be vouched in. Yes, you may proceed.
Good afternoon, Your Honors, and Happy New Year.
Happy New Year.
Most of the issues in this action were resolved in the appellate decision in Ross versus no
Ross.
parking, which that came down after our initial briefing, but before the subsequent briefing in this case. So I'm going to, with the understanding that that case limits the issues here, I'm going to try and limit it to the other things that were raised here. First off, I need to correct some allegations that were made in Con Ed's briefing here, where they said that we didn't allege, in accordance with the Ross decision, the permit is not a contract, but that we didn't allege anything about there being some other agreement outside of the contract in either our pleadings or our briefing below, and neither of those things are accurate. On page 21 of the record, section 30, or paragraph 38 of our complaint, which is the second cause of action against Con Ed, by reason of its breach of the DOT permits and the promises required to be made pursuant to New York City Administrative Code 19142, prior to obtaining such permits, Con Ed is liable. That is what the Ross court held to be an adequate pleading of a breach of contracts claim here. They also said that we didn't, in our briefing on the motion to dismiss before the lower court, raise that issue, and we did in two places. Page 53 of the supplemental record submitted by Con Ed, we said New York City Administrative Code 19142 also expressly requires the permittee to enter into an agreement with the DOT to comply with 19142. And on the following page, on supplemental record 54, we say, plaintiffs are entitled to prevailing wages under New York City Administrative Code, section 19142, as third-party beneficiaries of the defendant's agreements to pay prevailing wages, which emanate from the DOT permits. In order to get the permit, they had to make these agreements. So in both of those places, we're arguing that they agreed to do these things independently of whether or not the permit acts as a contract. So that's really the bulk of Con Ed's argument here, is that we waived this by not raising it below. We did raise it below in both of our complaint and in our motion papers, and they raised the same argument in Ross versus no parking. As we cited to in the papers, Justice Kern at oral argument said, be that as it may, it's all on the record here so we can address it. So I'll put that issue to the side for the moment. The other issue is, that wasn't raised in no parking, is the breach of contract claims against the contractor, San Mateo, because in no parking, the contractor had defaulted. There's two central issues here. One is that the documents submitted by San Mateo, including the Con Ed standard service contract agreement terms, specifically say, and this is on page 196 of the record at section 26, the contractor shall comply with all federal, state, and local laws, executive orders, regulations, ordinances, blah, blah, blah.
So the contract that San Mateo had required them to comply with 19142.
Exactly. They required them to comply with all laws.
So it was error to dismiss the first cause of action.
Correct. And that's the the Court of Appeals case in Filardo versus Foley Brothers says that where you have a provision that I will comply with all laws, that is a promise to pay statutory wages upon which workers can sue as third-party beneficiaries. Filardo was reversed by the Supreme Court on the basis that the statute at issue there did not apply to work that was performed in Iraq outside of the country. There's no issue here that 19142 applies to the work performed by these workers.
And your response as to the contractual disclaimers, it would be otherwise against public policy to have that.
It's specifically stated by this court in Roble versus Shaw Environmental. Given these precedents regarding workers' ability to sue as third-party beneficiaries for prevailing wages, the contract clause prohibiting third-party actions for violation of prevailing wage payments would be void as against public policy. That doesn't say on public work projects, this is void as against public policy. It says the contract provision invalidating actions as third-party beneficiaries for prevailing wage payments would be void as against public policy. That's already been decided by this court in Roble, and that's the law of New York.
Thank you.
Good afternoon, Your Honors. Happy New Year, and may it please the court. I'm representing Con Edison, not the third-party contractor. I actually would agree with Mr. Murray. I believe the issues as concerning Mr. Murphy, sorry, James. The issues as to Con Edison, at least, have already been decided in Ross. I think that leaves, as to Con Edison, the only claim remaining should be, was there this other contract as referenced in 19142? It's outside the record. There are 5 or 6 of these cases currently pending, both in federal court and state court. We don't believe there are, but we can take discovery on that in this action and determine whether that gives rise to any third-party beneficiary claims.
Thank you.
Thank you, Your Honors.
Very briefly on that note, because this is, I think, all we're kind of in agreement on what should happen here. The First Department in Ross did say that, in quoting 19142, it says that as a precondition to obtain one of these permits from the Department of Transportation, the utility is required to agree that the prevailing scale of union wages shall be the prevailing wage for similar titles established by the fiscal officer under 220 of the labor law. So that statutorily required agreement is what we're suing on for the breach here, which is what the Ross court held we're allowed to sue for breach of contract for. So if there's no other further questions, thank you very much, Your Honors.
Thank you. Thank you both.
Thank you.
Board of Managers versus Building 389 LLC.
Good afternoon, Your Honors. Happy New Year.
Yes, Happy New Year.
I represent the plaintiff appellant in the matter, and we're appealing the lower court's partial dismissal of the matter, dismissing the case as against the sponsor defendant and one of its managers, Ford Meyer, primarily based on the fact that the court treated each of the allegations against the sponsor and Cord Meyer under the warranty notice provision within the offering plan for the condominium. And our position is that that does not apply in the way that it's been applied in this case.
Because the warranty isn't a defect, correct?
Correct, Your Honor.
So you're focused on the water heaters issue.
The 15-year warranty.
Right, that you didn't need notice to comply, to be able to have them be liable for the warranty.
As to the 15-year water heater warranties that were not provided but were promised within the offering plan.
Right, but you didn't have to give them notice, unlike a construction
Under the
defect.
limited warranty provision of the offering plan, that's correct. Additionally, the limited warranty provision of the offering plan expressly applies to units, and many of the claims within this action are not specifically tied to the units, but refer to and relate to the common elements of the condominium as well. And that too is not covered by the limited warranty notice provision of the offering plan. Respondents has argued that we waived an argument with relation to the Martin Act barring common law causes of action. Plainly, it does not. That's well-settled law in this jurisdiction. The Martin Act could bar individual causes of action, common law causes of action, that are completely subsumed, that the facts alleged supporting them are limited only to a violation of the Martin Act. That is simply not the case here. And then as to the dismissal of the fraudulent conveyance causes of action, that is dependent on the dismissal of the other causes of action. And we would argue that that fraudulent conveyance causes of action should not then have been dismissed. Thank you.
Thank you.
Good afternoon, Happy New Year. May it please the court. With respect to any defect, it would require notice, and that's what the court held.
But do you agree that as to the water heater warranties, the notice provisions didn't apply?
My position on the warranty issue is that is a Martin Act, a purely Martin Act Attorney General requirement. You don't buy a condominium. An offering plan is a 300, 400-page document. No one bought and the warranty provision appears in Part 2 of the offering plan.
That wasn't my question. My question was, do you agree that the notice provision doesn't apply to whether or not the warranties were in place.
The notice provision does not apply to whether, I agree with that.
Okay.
But where I disagree, where I'm going is that the Martin Act limits that type of claim to the Attorney General, because what kind of warranty you're providing on a hot water heater is something that is mandated by the Attorney General to be in the offering plan. And that is purely a Martin Act issue. It doesn't fall outside of it.
Are you saying that the length of the required warranty is the same for all co-ops and condos and is governed by the Martin Act, not by the offering plan?
No, not no. The requirement to disclose what type of warranty you're providing is something that would not be in your general contract with anyone else. It's something that only the Attorney General requires under the Martin Act, and that the Attorney General has exclusive jurisdiction over that type of issue. It wouldn't have you can bring a breach of contract action for certain things outside of the Martin Act, but the Attorney General has exclusive jurisdiction under the Martin Act for certain types of claims, and this is one of those types of claims.
But is there a difference between omissions and affirmative representations when we're talking about the Martin Act?
Well, look, the bottom line here is there was a mistake. Rather than a 15-year warranty, which was set forth in the offering plan as was required by the Attorney General to be disclosed, there was only a 5-year warranty that was actually given by the manufacturer. That type of mistake is not a breach of contract. It's not fraud. It's not all these other things that the plaintiff threw into this action. It's a mistake that only the Attorney General has the position to say, hey guys, we forced you as the sponsor to disclose what type of warranties you are giving to these buyers in the offering plan.
Aren't the buyers entitled to expect that they're then getting a water heater with a 15-year warranty, and that the failure to do that is a breach of the sponsor's obligation to them?
It's a breach of the sponsor's obligations that the Attorney General has exclusive jurisdiction to pursue.
Well, wait a minute. If the offering plan, say 150, page 150 in the record where it describes an obligation to turn over the warranties, and 227 of the record, which is part 2 of the offering plan, which describes the heaters as being 15-year heaters on the roof, and the offering plan is incorporated by reference into the contract between two parties, in that circumstance, you don't think they can bring a breach of contract claim on the warranty?
Well, I think if you do that, John.
Or did I accurately explain what is here?
Yes.
Okay.
But
so why can't it be a breach of contract?
Well, then you get into I think that may trigger the notice provisions, which is what the lower court found.
No,
and you
because
also
it's a warranty. It's not a defect.
And you also have the fact that the control of the board, the control of the building was given up in 2016. The plaintiff had all these documents since 2016. They didn't even file this complaint until 4 years later, and then they added Cord Myers over 6 years later. And that's another reason why the court dismissed as far as Cord Meyer, because it was more than 6 years after the fact. They had possession for 4 years of this warranty claim, of all the warranty documents. And they did nothing for 4 years. And the position is...
Statute of limitations for a contract claim is 6 years.
It is 6 years, but again, my position again, I know I'm repeating myself, is that this type of claim with respect to the time frame of a warranty is in the exclusive jurisdiction of the Attorney General under the Martin Act. And they didn't contest that issue, and that's what the lower court found. And they don't even mention the Martin Act in their brief. And my position is they abandoned that issue. That's what the lower court found, and they have not contested it on this appeal.
Thank you. Would you like to respond to your friend's last point in terms of you're not contesting it on appeal?
We are contesting our notice of appeal. Notice that the appeal relates to the order that's being appealed in its totality. The issue that he's raising in terms of The Martin Act is against the plain, well-settled law of this jurisdiction. To the extent it's determinative, it should also be taken into account, even had it been waived, which it is not. It can still be raised on reply. The Court of Appeals of this state in 2011, I apologize, this is in the assured guarantee matter, held that a private litigant may not pursue a common law cause of action where the claim is predicated solely on a violation of the Martin Act. We're not disagreeing with that. At the same time, our allegations, our claims are not solely for violation of the Martin Act. The decision goes on, an injured investor may bring a common law claim for fraud or otherwise that is not entirely dependent on the Martin Act for its viability. Mere overlap between the common law and the Martin Act is not enough to extinguish common law remedies. Our common law remedies are our common law causes of action, are well pled, and the Martin Act simply does not bar them. As to abandonment, no, we've not abandoned that provision.
But essentially, your position is that they breached the contract in not giving you a 15-year warranty on the heaters, correct?
Yes, and as to the defects within the building also showing non-compliance with the offering plan. This isn't a matter as to the applicability of the limited warranty within the offering plan, putting aside the water heater 15-year warranties, which were not provided, though required. The limited warranty provision in the offering plan relates solely to units. It says specifically in those provisions, it provides an amount of time within which the purchaser of a unit has to provide notice of a latent or patent defect within that unit. We are claiming causes of action within units, but that is not the limit. That's not the totality of our claims, which is also making claims as to common elements as well.
Thank you.
Thank you.
Thank you both. Bi-Coastal Properties versus Solomon.
Good afternoon. May it please the court, John DeBaptist on behalf of the Corporation Council of the City of New York, representing respondents, appellants, Commissioner of Finance, and the City of New York. Your Honors, we are here today to ask the court to reverse the lower court's erroneous decision which granted petitioner's Article 78. The lower court erroneously allowed petitioner to misuse an administrative procedure designed to address clerical errors and errors in description in order, and petitioner basically used this in order to circumvent Article 7 of the RPTL.
Because what they were really trying to contest was the valuation and the assessment that would lead to the tax credit.
Yes, Your Honor. The main issue here is the valuation of physical improvements at the subject property. Here, the issue was replacement windows and whether these improvements were overvalued or undervalued. Finance's assessor found that the replacement of windows and nothing more at the subject property did not add value to the market value of the subject property.
Why would the MCI increase for the windows granted by the Division of Home and Renewal not constitute added value for purposes of this assessment?
Yes, Your Honor. So the DHCR order, as Your Honor is aware, DHCR is a separate entity that deals with basically providing adequate, safe, and sanitary low-rent housing in the state of New York. They're the ones that are in charge of rent stabilization and allowing increases in the rents of those properties. So there's no express local requirement that finance or finance's assessors consider an order from a separate agency. Each assessor at finance uses his or her own expertise in assessment of property and valuation when analyzing, for example, each application for a J51 once it comes into finance's purview. Here, the assessor looked at the replacement of windows and found that those replacement windows did not add to the market value of the property and so issued a physical increase of 0. What happened here was that petitioner brought in Article 78 alleging clerical error of description. This court, in a recent decision matter of 306163 3rd Avenue, has clarified that an error in description means a minor mistake, inadvertence, misdescription, or inventory error, none of which occurred here. And also, a clerical error is an inadvertent ministerial act, errors of mere form. Here, the assessor did not just, commit an error or a mistake. In fact, the assessor reviewed, the assessor looked at the window replacements and basically made a judgment call that they did not increase the market value of the property. And so the lower court erred because this court has issued numerous decisions, including matter of 9 Orchard, which reiterate the longstanding principle established in a Court of Appeals case, City of Mount Vernon, that challenges to the valuation of real property, whether over or under valuation, are under the exclusive province, of Article 7. Matter of 9 Orchard is critical because in that case, petitioner was seeking ICAP abatement benefits and arguing that it had received an insufficient physical increase as well, which affected its ICAP benefits. And this court's decision in that case stood for the proposition that every question regarding the valuation of a physical increase, which is a component of the assessed value, must be addressed only under Article 7 of the RPTL. And the court in dicta, continued on saying that claims, as a policy matter, claims sounding in property valuation could not be left to local clerical error provisions because it could create inconsistent outcomes and forum shopping, as has occurred in this case, because petitioner never brought an Article 7 proceeding in the 2020-21 tax year in order to, have two experts in an Article 7 proceeding each present their valuation opinions of whether, the windows increased the market value of the property and did not. That's the correct venue for substantive issues. Here, the only issue before the lower court was whether a clerical error had occurred, and a clerical error did not occur because the decision is not a ministerial one. Finance's assessor looked at the window replacement and, using his or her expertise, found that they warranted a zero physical increase. Additionally, the lower court ignored 9 Orchard, and this court recently, I was here almost a year ago on matter of Bajaktari v. Solomon, and also 2 months ago on 174th TIC owner, basically identical cases to this one, exactly
Well, I was
almost.
going to ask you about that one because I thought that was on point, Baskari, which I was on. So I was wondering when you were going to mention it, because it seemed to be identical facts.
Yes, Your Honor. They're identical facts in both cases. Again, the court
Same
found that,
respondent also, right?
yes, and finance had found that that the lower court had held that finance's decision was rational and reasonable because a petitioner had tried to use clerical error to circumvent and litigate these issues of valuation.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honor. Scott Goldberg for the respondent. May it please the court.
Counsel, I'm curious, how is this case different from our prior decisions?
Sure. So with respect to 9 Orchard, 9 Orchard involved a property that was seeking a change in the valuation methodology from an income approach to a construction approach. That is clearly something that has to be brought under Article 7. The Department of Finance's clerical error rule specifically says under 53-02C2, that's something you have to bring as an Article 7 proceeding. This case does not involve valuation. This case involves 2 specific provisions of the clerical error rule, 53-02A1, which—
You weren't trying to— The so-called error you were trying to correct was a determination that your client wasn't entitled to a J51 exemption. In what sense is that a clerical error as opposed to a discretionary decision by a decision maker?
Sure. In 2014, the Second Department decided a case called Better World.
We're not bound by them.
100%, and I'm not asking the court to be bound by that. But in 2016, the Department of Finance listened to Better World, listened to Judge Balkin, who dissented in that case, and they enacted a clerical error rule. The 2 provisions in this case that I'll cite to, you won't even find in the appellant's brief in their appellant's brief, in their reply brief, anywhere. They ignore it. They
You
are
agree that
distance.
what you're really contesting is DOF's determination that you weren't entitled to the exemption, right?
Yes.
And that was based upon the fact that the person who did the evaluation didn't think that the window replacement was sufficient to warrant such exemption. An assessment, basically.
I don't know if that happened. I know that what happened here is this. There was an increase. My client did an extensive amount of work. It's in the record. He went to HPD, got a certificate of eligibility for J51 work. It was even an enhanced.
He could have sought a remedy under Article 7.
No, but this, the CER, the clerical error rule, specifically says that we will correct as a clerical error. The Department of Finance invites taxpayers. We will correct as a clerical error the failure to process a partial exemption. That's what the language
It wasn't a failure
says.
to process. It was a process. It was processed in a way you didn't like. That's different from a failure to process, isn't it?
Well, the reason they didn't issue it is because they also did something. What they did here, they increased the assessed value. So again, we're not contesting valuation. Department of Finance did increase the assessed value of the property. We're happy with the valuation. We're not asking for any calculations. But what they did was they misdescribed that increase. Another 53-02B2, as an error in description, says if the physical increase is either not listed or placed on as an equalization increase, that is something that they will correct as an error in description. We even cite in our brief to several cases.
But even that case that you mentioned, that Better World case from the second department, they actually go on to describe what a clerical error is as a minor mistake or inadvertence. I mean, this is not what this is based upon the valuation.
Oh, no.
You're saying that it was done wrong.
Respectfully, Better World didn't do that. Better World rejected
I'm
that
reading
argument.
it, right.
That was the argument that Department of Finance raised in Better World, and that was rejected. They said if that's the case, then it would render 11-206 of the Administrative Code superfluous. And then Department of Finance enacted this rule
No,
2
that's
years.
what Better World says. A clerical error is simply a minor mistake or inadvertence, such as making a mistake in a writing rather than a mistake in judgment. That's Better World, 122 AD 3rd at 36. I mean, I'm reading.
Okay, I don't know where exactly. It's a lengthy decision, but
I just told you. It's at page 36.
okay, thank you.
Welcome.
But
And I seem to recall, it's all coming back to me now. You made the same argument in Bhattacharya.
well, Bhattacharya is distinguishable because here
But you made the same argument in terms of citing or attempting to cite to matter of Better World.
why is it okay that the Department of Finance in these litigations ignores the language that they set forth in the clerical error rule that says that these items are correctable? It says a misdescription of an increase as a equalization.
This isn't a misdescription of an increase. They looked at all of the windows, they made an assessment that it didn't warrant, the valuation didn't warrant the exemption. That's not a misdescription. In fact, that's a very specific description of it's not, the value isn't there.
But here also, the assessor in this case submitted an affidavit, and he said, obviously he wasn't aware that there was a Department of Housing Conservation Renewal order that increased the valuation by the rental roll by $30,000. He says in his affidavit, this is Lancelot Abrams, he says in that affidavit that windows don't generally increase, he felt, won't generally yield a rental increase. But here, it did. Here, there was actually a DHCR order, and that's the only way a rent-stabilized apartment building can have an increase to rents. These are buildings that are strictly
What you're describing is a decision based on judgment, which is what Article 7 is designed for. It doesn't explain to me why you're here on this.
I think that the problem is, we're not saying that maybe on the Article 7 proceeding you would have been successful, who knows? But on an Article 78, it's the wrong vehicle.
But I even cited in our papers to 3 cases, it was in the lower courts also, Kimzo, Park Hill, and Pula. These were 3 actions that were Article 7s, but they were also clerical error cases where there was no physical increase and J51 exemption benefits were issued by the Department of Finance pursuant to the clerical error rule, and it's not even disputed. The point here is the Department of Finance invites taxpayers to utilize this clerical error rule to correct this exact type of error. these errors, these adjustments are made all the time, and to say that this has to be Article 7 when it directly conflicts with the exact language of the clerical error rule is just not correct.
Thank you.
Your Honors, I just want to briefly touch upon the two cases that petitioner seems to claim that they're not exactly the same, and in his papers, he tries to distinguish. 174th TIC was also a mod rehab case. In that case, the CRC was actually for more than petitioner's current case. And the main issue here is that a clerical error is merely an error of mere form. If petitioners want to debate the valuation, the physical increase, the amount placed upon a property for, whatever type of renovation, in this case, in the J51 context, the physical increase, they have to do it through an Article 7 proceeding where there will be two experts and both experts can flesh this substantive issue here. The lower court erred because it should have found that the determination was rational, reasonable, that there was no bona fide clerical error because the valuation was exactly as finance had intended. There was no error of mere form. The replacement windows did not increase the market value. And it seems to me that, petitioner seems to be claiming that just because Department of Finance entered into settlement agreements on cases that have completely different facts, that all of a sudden, it shouldn't be able, the point of settlement agreements is to try and not come to litigation and waste money on litigation.
Counsel, just to clarify something, the owner here got an abatement under J51, correct?
Yes, that is correct.
And you heard your friend say that he was happy with the valuations, correct?
Correct, Your Honor.
So I'm trying to understand the whole benefit of the exemption. The exemption pretty much allows someone who has a physical increase to be valued at the pre-rehabilitation value, correct?
Correct.
Like you're frozen in time.
Yes, Your Honor.
But he is getting benefits under the law.
Yes, he's getting abatement benefits. He's just not getting the, the exemption benefits because the physical increase was zero, so it didn't trigger the J51. And just to finalize.
That's it. Thank you.
Thank you, Your Honor.
Barbieri versus 175 West 12th Street condominium.
May it please the court, Elliot Kroll for the pro se plaintiffs in the case. This case has been pending for a long time. There are only 4 causes of action that are still material: 3rd, 4th, 5th, and 14th. The motion court improperly denied our motions for summary judgment with respect to liquidated damages and with respect to our application to install a gas grill. The liquidated damages that were imposed on the plaintiffs in this case were a penalty. That is not allowed in the state of New York. The motion court also erred in granting the entirety of the defendant's motion for summary judgment. Motion for summary judgment under CPLR 3212B requires evidence, admissible evidence. We met our burden, the defendants did not. With respect to the issue of liquidated damages, the IAS court made clear that the purpose of the liquidated damages were to encourage plaintiffs to complete their work. This court and some of the members of this panel have ruled in Atlantis v. NABE that by itself renders the liquidated damages a penalty. The Court of Appeals in the City of Rye case, Judge Breitel, writing the opinion, made it very clear that where the liquidated damages are not to cure a pecuniary damage, it's a penalty. The president of the condominium board, Craig Rea, testified in his deposition, which was part of the record on appeal, that they didn't want renovations to go on forever. That's exactly what the city of Rye says constitutes a penalty.
Well, how were these damages conspicuously disproportionate to foreseeable losses?
I'm sorry, Your Honor.
How were the liquidated damages not in line with what the foreseeable damages were? The co-op board is claiming, or the co-op is claiming, that the damages arose from the loss of the use of the common elements, extra labor required to maintain the areas affected by the prolonged work, as well as fees and expenses incurred as a result of nearly a year of delay.
That is actually what Craig Rea, the board president, said in his affidavit, which was the only affidavit submitted in support of the summary judgment. But that is not what the evidence is in this case. When he testified in his deposition, he testified that's not what he said it was for. He said it was to make sure it did not go on forever. And in fact, Your Honor, the other aspect that I'd be remiss in not noting is that at every step of the way, the defendants, call these penalties. Every member of the board, I deposed 7 of them. They all called them penalties. The alteration agreement.
They called them penalties is not binding on us, right?
Your Honor, absolutely. However, the fact is, words do have meaning. They called them penalties in their depositions, sworn under oath. They called them penalties in the alteration agreement. They called them penalties in the letters that we received levying them on this. Their lawyer called them penalties. So at some point, there are penalties. And the fact of the matter, oh, I'm sorry, Your Honor. The fact of the matter is, if they are not to accomplish a pecuniary remedy, the Court of Appeals in the City of Rye said it means that it's a penalty. It's not liquidated damages that are recoverable. Now,
So when you entered into the agreement, or when there was an agreement that the work was going to take place, was there not a provision about liquidated damages?
Yes, as there is in every single.
Right. So, but it talked about liquidated damages. It did not speak about penalties, right?
Yes, it did. Absolutely spoke about penalties. In paragraph 4, it described liquidated damages in paragraph 7 as penalties.
But the liquidated damages were described as what?
Penalties. They used the word liquidated damages and then said in the very, like two lines down, they called them penalties. And in paragraph 4 of the same agreement, they called them penalties. But one more thing.
You signed that, right?
I'm sorry, Your Honor?
You signed that agreement, right?
Yes, like every other decision where the Court of Appeals or this court has overturned liquidated.
And you and your co-owner are both lawyers, right?
Yes, yes, Your Honor. And I don't see why that, but one other point that must be mentioned here, right? There's no evidence in this case that the delay was the cause of the plaintiff. The defendants put nothing before any of the motion court that the cause of the delay was on us. And one last point that I want to get in here before my light goes on, which is that there are no determinations in this case by the condominium about anything. They didn't submit one single evidence that complies with 2.16 or 2.17 of the bylaws, and the law passed by the legislature, signed by the governor, and the Condominium Act 339U requires that there be bylaws, and the board and the condominium had to comply with it, and they didn't. And the motion court effectively found that in denying their application to dismiss based on the 4-month statute of limitations in Article 78. The last point I'd like to make is that, as we say in our papers, and it's very clear from sitting here today that the bench has read everything very carefully, that we feel that the Guggenheimer case makes clear that the 3211E argument we made is valid. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Jackie Aiello for the respondent.
So in response to his last point, the reason the court below in the earlier decision that denied dismissal was because the memo of law was not considered, correct? There was no substantive finding by Judge Bluth.
That's exactly correct.
Which didn't bar you from bringing in action for a motion for summary judgment, correct?
Exactly correct. There was no determination on the merits. My former colleague had inadvertently left out the memorandum of law, didn't realize until it was pointed out in opposition. There was no determination on the merits on the motion to dismiss, the 3211 motion to dismiss. On the liquidated damages issue, as the court has pointed out already, the parties had freedom of contract here. We're talking about two very sophisticated appellants. They had reviewed the agreement. They were aware, because they had put in the alteration agreement, that their project was going to take longer than the 90 days permitted before incurring liquidated damages. They did not attempt to negotiate how long they would have in order to not incur liquidated damages, or talk about a lesser amount of liquidated damages.
What about his argument that the board managers and the witnesses kept, and inside the actual contract itself, it refers to it as penalties?
I would say that while words mean things in contracts, first of all, lay people, how they call liquidated damages, if they consider them, if they call them penalties, doesn't make it so, and the law says that. You have to look at really what the purpose of it is, what is stated in the alteration agreement. The alteration agreement calls it liquidated damages. Statements by lay people calling it penalties does not make it so. And not only did Mr. Rea in his affidavit talk about the things that happen when there's an inordinate delay in a project, but it is, of course, common sense. The excessive amount of dust that needs to be cleaned up, the amount of time spent by the super, the porters, management, the disruption to neighboring apartments, the amount of time spent by the board, the amount of time spent the use of the elevator that would otherwise be accessible to others. There are a number of factors that this liquidated damages clause is meant to compensate when it's things that are not incredibly tangible and you can't put an actual dollar amount on it, but that is the purpose of the liquidated damages. So I will also say that the issue on authority on whether the liquidated damages could have even been part of the alteration agreement, the bylaws are very clear in terms of the condo having the authority to put forth terms and conditions for alterations, and whatever terms and conditions they feel are necessary within an alteration agreement, they had the authority within the bylaws to write this alteration agreement and, of course, include a liquidated damages provision.
On this record, with respect to the denial of the plaintiff's right to have a gas grill, there's no issue that when it was rejected by Mr. Erickson, the board's architect, in his earlier letter when they made the first request, that was not done timely, correct?
The first one?
Yes.
The first one was done timely.
That's my point.
Yes.
It was the second one that was 2 days after the 30-day period that they called into question, correct?
Yes, although I don't agree that it was 2 days late. What appellants acknowledge and what the bylaws say is that it has to be a 30-day response upon receipt. They say in their complaint, the appellants say in their complaint, and it is so in the record, that January 3rd, they had received it, acknowledged receipt, appellants acknowledged that, and then it was 25 or 27 days thereafter.
But the bottom line, with respect to their initial request, it was timely rejected, end of story, no declaratory judgment on that issue, correct?
Correct, Your Honor, yes, yes. On the gas grill issue, I would just point out that there's an argument that, I think it's on the motion to dismiss papers that we had filed initially, that there was some alleged judicial admission about it being past 30 days. If you read exactly what the motion papers say, it does not say that they responded after 30 days of receipt. It just says after 30 days of the request being made, which is not inconsistent with what we're saying now. Of course, it was a 3211 motion, so it was going based off of just what the pleadings said by the appellants, but it was not inconsistent with the argument we make now.
Thank you.
Thank you.
Just very quickly. So on the issue about the fact that lawyers signed this agreement and the record on appeal at 882 from their brief and the Ray affidavit at record on appeal 650 to 651, they admit it was an adhesion contract. It could have been Oliver Wendell Holmes being asked to sign the agreement. We didn't have a choice. With respect to the
Didn't have a choice as to whether or not to sign the agreement?
we had bought correct, Your Honor, because we bought the apartments with the stated view of renovating them in the first instance, and a year later, a little more than a year later, they're giving us an alteration agreement saying if you want to combine, it's actually a total of 3 apartments, you have to sign this agreement. That's their admission in their papers that it was an adhesion contract. We didn't have a choice. We had to sign it. It's in the record on appeal.
What page is that?
The references, Your Honor, in the record on
Alteration that
appeal.
would have taken less than 90 days.
Excuse me, Your Honor?
You could have proposed an alteration in a different form or negotiated for an extension. You had lots of choices.
Well, as we sit here now, what the record states, and understand that we never thought, and the record is clear on this, there's no evidence we were the cause of the delay. We never thought for a second, either of us, that we would be penalized or levied any kind of liquidated damages, no matter what you call it, if we were not the cause of the delay.
Where does it say that in the agreement?
It says it in the law. It says it in the
In
Seidlitz
the
case.
agreement that you signed, you and your co-owner as lawyers signed an agreement that didn't have any provision like that, but you were relying on the provision that wasn't there. Is that right?
And we also relied upon the fact that there was supposed to be a master calendar, which didn't exist. We also relied upon the fact that the board would make a determination as to when the work is complete, and there's no evidence in this case or anywhere that the board ever made a determination about anything. And we also relied upon the fact that there were 4 other provisions in the agreement that provided for compensation to the board in case there was any damage. And the final thing I just wanted to note is that the very things that were being said by counsel just before about the reason for that provision is exactly why there are penalties under the law in the state of New York. Thank you all very much.
Thank you,
Good to be
Bob.
here. Thank you.
Gentile versus Juva Skin and Laser Center.
Good afternoon, Your Honors. May I please the court? My name is John Clark. I represent the appellant, Marlena Gentile, in this case involving claims for negligence and medical malpractice. This appeal arises from a defendant's motion for summary judgment, which was granted by the trial court. We appeal that decision. The trial court also refused to consider our cross motion for summary judgment. This case arises in the med spa context, which is important to understand in that this is an unregulated business space right now in the state of New York. You do not have to have a medical license to render laser services. We see it with laser hair removal.
But on this record, Ms. Kramer, who was the anesthetician who did the treatment, was being supervised by a doctor and nurse practitioner on this record, doing the settings and all that other aspects, as well as relying on their diagnosis and treatment that the laser therapy was appropriate for the psoriasis or even for the lichen planus, whatever treatment isn't. So this isn't an unregulated situation here.
Well, the physician's assistant testified that she wasn't there. She has a special needs child that required her to take prolonged leave from the practice during this time. She actually only saw the patient once during the actual time that the laser services were being provided. So these services were being provided without any oversight at all from a medical professional during the months of March and April of 2018. Now, when this all began, my client originally began in the dermatology arm of this business. Dr. Katz, who owns the practice as a business owner, also is a dermatologist. He then had my client referred to the med spa, which is where cosmetic procedures are performed.
But she was referred to the med spa to treat the dermatological issues that was diagnosed medically.
Well, at that point in time, the physician's assistant, Marianne Woody, who is not part of this appeal or represented by the defendant, respondent's counsel, was on leave. So she was not there at the practice. She testified to this, and Jennifer Kramer testified that she provided these laser services without any physical oversight at all from a nurse.
I thought Ms. Woody did, in fact, see your client.
This was before the laser services were actually provided, well before, months before.
And because Ms. Woody prescribed a steroid spray, right?
Correct. This was truly in the fall of 2017. And then as the laser services began in March, Miss Woody was out of the picture. Now, continuing on with,
Well, given the fact that your client saw numerous dermatologists, other physicians, why don't we just get to the actual motion? So do we have a motion for summary judgment? And your stating that, one, they didn't make out a prima facie case, but also, how did you defeat, assuming they did make out a prima facie case, how did you defeat that showing?
so the expert that we had in support of our cross motion, as well as
The urologist,
urologist, who's the owner of a med spa and actually provided care to my client.
which you just stated initially, med spas are not, they're not, there's no real overseeing of med spas, right?
It's important to note
But what I'm trying to figure out, what we're trying to figure out is how does the urologist, I understand that he owns the med spa, how is the urologist an expert in dermatology and able to give an expert opinion as to the treatment received by your client?
So this med spa that was owned by my expert, Dr. Ackerman, was operated in New Jersey, just over the border. So it's a different situation in terms of how New Jersey regulates New York versus New York for med spas. The fact is that Dr. Ackerman owned and operated a med spa that provided laser services to my client. She evaluated, along with her core med team, my
But
client.
when we look to whether or not an individual is actually an expert in a particular field and therefore is qualified to give an expert opinion, we don't look to what their position is really in terms of another state. We look to their expertise in that particular field. So would we not need an expert in dermatology to state their opinion as to the dermatological issues by your client?
The trial court in this case actually said that the reason that my expert's affidavit was not considered is because the standard of care was not provided. There is no standard of care for a non-medically licensed individual in the sense of Jennifer Kramer. Irrespective of that.
But just going back to that, I thought that when Kramer was operating the laser, the settings were always done by someone who had the medical background. At least that's what the testimony was.
That's false, and she set the settings herself based on observation of my client. And also, I would just like to say that my client, or my expert, Dr. Ackerman, did state what the standards of practice were for something called a test spot. Very important. You use
But the record showed that a test spot was done.
by my client's expert, not the defense. Miss Woody testified she never did a test spot. I think you might be confusing, Your Honor, patch test with a test spot. Very different. A patch test is an allergy test that was done 6 months before. A test spot is when you do a very small area treated with a laser to see how the person's skin reacts, because your skin's complexion can cause different reactions. You do a small test first to then see if that setting's appropriate.
Kramer did state that all treatment performed by her was under the supervision of one of the medical professionals, doctor, nurse, or physician's assistants, with the settings and duration of the treatment decided by them at each session prior to Kramer's proceeding. That's what she said.
Dr. Katz testified that he never was around. He didn't oversee it. He said Woody, the physician's assistant, did it. When Woody testified, she said she was on prolonged leave due to a family-related issue. So even though that was said, it was proven via Katz's testimony and Woody's testimony that that was actually just not true.
Just going back to Ackerman's affidavit, like she made assertions about that plaintiff was treated for psoriasis, which she didn't have. How's she qualified to do that? And then just lending itself from that particular misstatement, she made other erroneous misstatements about the length and time of treatment. And if I'm not mistaken, inside her affirmation, she made reference to statements as as a qualified person in laser professional, which is very vague. I don't even know what that means, you know? So I just don't know how you would have overcome, you know, your particular side of the burden.
Sure. So my expert did not have to be a dermatologist. An analogy I can use is that.
But she was making assertions as to the fact that the plaintiff didn't have psoriasis and she shouldn't have been treated.
By the defense in the case that she didn't have psoriasis. That's a medical fact that's undisputed. In fact, they're trying to argue she had lichen planus from a biopsy that they say was taken from my client's back, an area that was not treated with their laser. Why would a biopsy be taken from my client's back if that wasn't an area that was going to be treated with the laser? If you look in Juva's records, there were a variety of skin issues being dealt with in the beginning. Eczema, a cat scratch, bed bugs, all these things. The biopsy for lichen planus, as defense testified or argued in the underlying motion, they're trying to use a biopsy for my client's back to establish she had lichen planus while then saying they never provided laser services on my client's back. Makes no sense. That's like saying you took a biopsy to test if someone had cancer and then you don't actually provide cancer treatment before that biopsy is found. It's inconsistent. And psoriasis is now acknowledged by everyone in this case that is something my client never had.
Thank you. You have time on rebuttal.
I got to clear up something. I represent all the defendants except the nurse practitioner. Counsel just said this treatment occurred in the context of med spa. This treatment had nothing to do with a med spa. My client had a dermatology practice, 3 board-certified dermatologists, and he had the beauty part, the cosmetic part. Okay? This was treatment for skin disease. Okay? And in their brief, they say something I want to read to you. They said the defendants were quick to refer the plaintiff to their med spa for anything and everything from Botox injections to laser service for an unknown condition. This patient was never sent to the med spa. She was treated in the dermatology section for skin disease. This was not a case where she had wrinkles or brown spots or hair removal. She was treated for skin disease, okay? And it turned out she didn't have psoriasis. She had lichen planus. When the pathology slides were re-reviewed by another dermatopathologist, my client relied on the interpretation. And to say this is a negligence case, the allegations, there is a negligence cause of action. The allegations in there are treating the patient for a condition she didn't have, misdiagnosing psoriasis. The method and manner she was treated, the frequency, duration, and laser settings. Treating her without a confirmed diagnosis. This is pure and simple medical malpractice. It's not negligence. But it doesn't matter because they cite 3 cases, and they're very interesting cases. One is, I can't even pronounce it, Desani case. That's where the lower court, it was Judge Mansonet, granted summary judgment on res ipsa loquitur, and this court reversed saying you need an expert. If you need an expert, you need a qualified expert. Then there was the Salas case.
So the bottom line from your point of view is that the urologist that they rely on was not competent to determine whether Dr. Katz's standard of care was a departure.
That wasn't my point, but I agree with that. My point is even in cosmetic cases, Salas and McCabe, they had a dermatologist testify, board-certified dermatologist, on the hair removal cases. So whether you call it negligence or you call it malpractice, you need a competent, their cases show you need a competent expert.
Is there any weight to their argument that Kramer, being an aesthetician, acted not under the supervision of the medical professionals?
Well,
and therefore, that's why the expert that they provided might be sufficient.
2 answers to that. You still need an expert. You still need an expert, at least for causation, and that's what the lower court said. When he says Woody was out of the picture, look at the notes I cite. It was either Miss Elliott, a PA, Miss Woody was a nurse practitioner. Miss Kramer signed a note April 9th. Elliott a note on April 11th. This is all during the laser treatment. Miss Elliott again on April 16th. And Miss Woody has 2 notes during the laser treatment. She wasn't out of the picture. This patient was, and one note was by Dr. Katz. So this patient was seen during the laser by a doctor once, a nurse practitioner, or a PA. And the lower court, it's interesting, they don't cite the Berkowitz case versus Equinox. In that case, this court said laser hair removal is not medical malpractice, it's negligence. But they also said then you can't make a claim for informed consent. So they left that case out. And it's important to note that Dr. Ackerman got to submit 2 affidavits. And in neither affidavit did she say she's ever treated skin disease, she's ever used an extract laser, she even knows the difference between psoriasis and lichen planus. And the real issue in this case is, did this person have burns from a laser, or did she have lichen planus?
Wasn't there another expert affidavit from Tatiana's?
A PA who had been admitted 1 year. I cited some cases, a PA.
But she stated in her affidavit, if I'm not mistaken, that there were significant burns as a result of the laser treatment, right?
I don't recall that. What I remember is citing the cases, a nurse practitioner is not qualified. They're not a PA, a nurse practitioner. So I just dismissed her affidavit. And it was also submitted late, and the court didn't.
It was a Sir
reply.
reply or something.
What we left
a supplemental expert affidavit.
Yeah, because what they did was they opposed the summary judgment for the cross motion for summary judgment. So that gives them the right, supposedly.
Well, that was a part of the cross motion for summary judgment, and I think that was the base, and then that was denied, right?
It was actually in the reply in further support of the cross motion. It wasn't submitted with the cross motion. And I'll just leave you with this. This person has marks on parts of a body that were never treated with the laser. They never addressed that. They never addressed 10 other
Well, what about your friend's comment as to the biopsy to the back?
You take a biopsy just to see what the condition is. It's not like he says cancer. You treat the areas. They treated the arms and legs. The biopsy is to tell you what the condition is. You don't treat the entire body just because you think you have psoriasis on the whole body. Thank you.
Thank you.
First off, with regards to the focus on the dermatologist, Jennifer Kramer is not a dermatologist. We are assessing whether she was negligent or even in the sense of medical malpractice.
Yeah, but we know generally in hospitals, when you have residents or interns under the supervision of an attending physician, that generally it's the attending physician that's making decisions here. In this instance, on this record, Ms. Kramer is doing the procedures under the supervision of either Dr. Katz, Ms. Woody, or P.A. Elliott. That's what's here. Now,
There's 12 sessions, Your Honor.
and you have a claim of negligence against her that you think should be a viable claim, when this is a med-mal case.
So with regards to the actions of Jennifer Kramer, the test spot, the failure to do it, the failure to take one, as a standard of practice, whether it's a medical malpractice claim or a negligence claim, there's a customary standard for safety to make sure that the person's skin reacts appropriately to the laser before you start lasering the whole body. That wasn't done here, and it's testified to by Dr. Ackerman, who owns and operates a med spa that actually treated the patient. She's a treater or a provider for laser services. To say that she's not qualified, she did a test spot on my client as a patient at her practice. To say that that alone doesn't demonstrate she's qualified to talk about test spots and when they're relevant and needed for someone receiving laser, that's self-explanatory. Now, the last remark I just want to make it with regards to the lichen planus. They argue that they know it was lichen planus because of a biopsy taken from an area they didn't treat. The fact is that by arguing and admitting that there was no treatment on the back, that means there's no foundation to even say my client had lichen planus. Who's to say that?
One second, wasn't there a Dr. Bloom that your client saw who basically had lichen planus throughout his medical record, and that hyperpigmentation here, which is what your client is complaining of throughout her body, is sequelae from lichen planus?
So he argued, that's what he said. He looked at the slide and said lichen planus. He never attributed everything else that my client was there for to lichen planus. That was a separate analysis. He had the slide. He said a differential diagnosis, which means he's not sure, but his best guess is lichen planus for the slide for the back. He never says that she has lichen planus throughout her body or that that's what caused the scarring. Now, again, it makes no sense that you take a biopsy for a rash that's being lasered afterwards from the back if that's the same rash that's being lasered on other parts of the body. It doesn't make sense. Now, with regards to the negligence claim on Kramer again, let's say you're at a hair salon. You get your ear cut by the person cutting your hair. That person doesn't need, then you compare that against a plastic surgeon that does hair implants. If you're a hair surgeon or a plastic surgeon, that doesn't mean you're qualified to talk about what the hair salon employee did, negligent or not, to cut your ear off. It just means that you work as a plastic surgeon in the area of placing hair. This is the same exact thing. There are plenty of dermatologists that have never used a laser ever in their career. Their expert never even lays a foundation that he's used a laser once in his career. How is he qualified to talk about Jennifer Kramer's actions? He might have never used one.
Thank you. Thank you both. NY 2015 Boat v. 2435 Kingsland.
Good afternoon, and may it please the court. Joshua Marks, pro bono counsel from Castlewoods Benson Torres and co-counsel with the Legal Aid Society on behalf of appellants Eric and Stephen Shapiro. The Supreme Court's decision to grant respondents' motion for summary judgment and enter judgment of foreclosure prior to any discovery having taken place in this action was legally incorrect for 3 reasons. First, the Supreme Court incorrectly held the defense of civil usury was unavailable to the Shapiro brothers because the loan was technically made to an LLC. In making this holding, the Supreme Court overlooked that the LLC was set up without the knowledge of the Shapiro brothers to avoid the safeguards in place for residential mortgages, and crucially...
Well, without their knowledge, but they signed off on it, right? Did they not sign off on it, on the LLC?
The only document we have regarding the LLC in the record right now, Your Honor, is the articles, the LLC articles, which have no wet ink signature on them. They're simply a typed signature.
Isn't one of the Shapiro brothers, wasn't their address listed as the residence, or the business address for the LLC?
I believe the business address for the LLC was actually an address downtown that they did
99
any...
99, okay.
Exactly, which the Shapiro brothers have disclaimed any knowledge of that address or anything to do with that address. So there's a dispute of fact regarding how this LLC was set up and who actually set up this LLC. So that was completely overlooked by the Supreme Court. Additionally, even if the LLC were properly set up, it exists solely to take the funds that were distributed as part of this loan and pass them on to the Shapiro brothers, who were then going to use the funds for personal expenses. In such a situation, the New York Court of Appeals has made clear that the defense of civil usury is available, even though there's technically an LLC defendant. And in opposition to this appeal, the respondent has not put forth any argument against that proposition of law. The fact that the court failed to even conduct this examination is legal error and requires reversal, largely because had it done any sort of examination into whether the loan was civilly usurious, it would have been clear that there were numerous questions of fact regarding the amount of interest charged on this loan.
We have a $9,000 commitment fee, $7,500 exit fee, $4,250 as a legal lender fee.
Yes, Your Honor. There was also a $3,000...
Were the Shapiro brothers informed of any of those charges before the closing?
The Shapiro brothers found out about those charges at the closing, Your Honor, as part of the closing set of documents.
Well, that's only one brother, because one brother wasn't there, right?
Correct, Your Honor. If we are imparting the knowledge of one to both, then collectively they found it at the closing. However, one did not even attend the closing, so that brother had no knowledge at that point. So all of those fees that Your Honor just listed, if those fees constitute interest, which the Court of Appeals has been clear is a question of fact, then the loan would be civilly usurious. It would surpass the 16% threshold, and it would be declared void, ab initio.
They weren't even given access to a sizable portion of this loan, correct?
Correct, Your Honor. That does not even touch upon the fact that $103,000 of this loan was sent to a separate account that the Shapiro brothers, again, had no knowledge of, were unable to.
And if you took that into account, it would be a criminally usurious.
Absolutely, Your Honor. If that, even were that amount not considered interest technically, but just considered non-dispersed funds, then the amount of the loan drops precipitously. By our calculations, it's around $120,000 or $130,000 at that point. So the amount of interest charged well surpasses the criminal usury level at that point.
So from $300,000, we get to $103,000.
A little bit more than that, Your Honor. There's about $130,000, I believe. Yes.
And the disbursements were not told to the Shapiro brothers, nor do we know exactly what we know what they add up to. Is that correct?
The disbursements?
Yes.
Yes. So the Shapiro brothers actually received about $75,000. Initially, about $150,000 were sent to a title company that was used to pay off other outstanding liens and judgments and things on the property. The remainder of that money was remitted to the Shapiros. That was around $75,000. That's all the Shapiro brothers actually received from this loan. And the $150,000 or so is the only amount the Shapiros have benefited.
But they're paying back. They were supposed to pay back $300,000.
Absolutely. The judgment was for the full $300,000 plus interest on that amount, which is important to note, Your Honor, that on appeal for the first time, the respondent has now admitted that $103,000 was not dispersed. It was actually recouped to the respondent, and whether or not they attempted to further actually give that back to the Shapiro brothers through some other account is a question of fact, but it was certainly not remitted. So the judgment of $300,000 cannot stand on this record at a very minimum.
The motion court entered judgment for $300,000 and directed the sale of the property?
Correct. $300,000 plus interest, Your Honor.
Plus interest.
As well as finding the property non-divisible and directing sale of the property. So the judgment on its own must fall, but there are also myriad questions of fact regarding the civil usury defense as well.
And the basis for the lower court, for the motion court's decision was that there were documents in support of the $300,000 loan?
I see my time is far. Can I?
You can answer.
Your Honor, the motion court held that the court held that there were documents supporting the $300,000 loan, including the note and some of the other documents that were submitted. However, the court also held that the civil usury defense was waived and did not examine it. It held the fraudulent inducement defense was waived and did not examine it. And it also, no discovery took place, crucially. So for the first time that the Shapiro brothers even found out about $103,000 coming back was on this appeal. So we have just so many unresolved questions on this record that it needs to go back. Discovery needs to take place, and then at that
Was the motion court made aware of the allegations as to the relationship, the attorney-client relationship between the Shapiros and, is it Broshwhite?
Yeah, the motion court was made aware through the affidavits of the Shapiro brothers, and that's in the record at page 448, paragraph 16. The brothers mentioned Eric Shapiro, who attended the closing, notes that the first time he ever met or spoke to Mr. Braunschweig was at the closing, that he did not retain him, that he does not know who did retain him. So the motion court was made aware of that.
But he alleges that Mr. Braunschweig was retained by the lender, doesn't he? His affidavit alleges that Mr. Braunschweig was retained by the lender, I believe.
I believe he does, but he definitively can state that he does not know how he ended up there.
Right, but he was told, Mr. Shapiro was told that Broshwhite was his attorney, was representing him for the purposes of the closing.
Exactly, he was told that he was.
And that's what discovery might clear up.
In discovery, it would certainly clear that up. It would be one of the first things to look into, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors. Daniel H. Richland for the respondent. I don't believe many of those facts that we just heard or positions that were taken are particularly accurate or were supported by the record.
Almost everything that I heard counsel say was in the affidavits of either of the Shapiro brothers. So I'm not sure why you say that it wasn't supported by the
So
record.
can you give an example or examples of what was inaccurate?
Sure, of course. So if you take a look at the two affidavits, which are the core of what they're basically relying upon, they're around 445 to 454. There's actually no allegation that the lender hired Mr. Braunschweig. If you read those affidavits, they essentially suggest that they spoke to Mr. Jonathan, who was a broker they found through the internet.
Well, Mr. Jonathan was the one who set this whole thing up.
Mr. Jonathan is their broker, correct?
And he said that he had relationships with the lender, which is why he could get, that's not in the record. I believe that was the representation that they said that he told them. That's part of the record. And so that gets us to the point of discovery.
Glad you asked, or glad you're saying that. If you read those affidavits, they actually don't mention what the relationship between Jonathan and the lender is. What they say is that
Well,
they tried to-
Jonathan explained he could get defendants a loan, but at a higher than normal interest rate.
Yes,
And because he specifically had a relationship with lenders.
Right.
That was the basis of their claim that there was a relationship between Jonathan and the lender because the broker said so.
Well, that's the interesting part, because that doesn't work under the agency theory, Your Honors. You can't have an agent saying things, and you can't rely upon what a purported agent is saying. And this is where this whole argument falls apart for the appellants. The problem here is there is no evidence, and certainly none in this record, and certainly not even an allegation, that Mr. Jonathan was an agent under any recognizable theory of agency for the lender. So if Mr. Jonathan, as a separate party, separate entity, did things, that's not attributable to the lender. And because of the particular procedural posture of this motion, and I really want to explain it like this, we moved for summary judgment. There was no issue, and there is no issue, that we made our prima facie showing. And you've been hearing summary judgment cases all day today. Then there are 60 affirmative defenses. There was no showing that any of those affirmative defenses had merit, and the appellants did not actually take the position that any of those defenses had merits. So what we were left with were two unpled defenses, civil usury and fraudulent inducement, raised for the first time in opposition to summary judgment and supported by these two affidavits.
So 2435 Kingsland, you represent 2435 Kingsland.
I do not. That's the borrower, Your Honor. I represent the respondent, New York 2015 Boat LLC.
2435 Kingsland LLC, is that Jonathan's group?
From our understanding, it's the guarantor's entity, because the parties who are appealing are the guarantors, not the borrower. The borrower is that defendant, and they are not appealing any of this. They're not taking any of this position, and that's, as far as we know, their entity. And this is the whole problem. How do you get to discovery on unpled issues? How do you get to that? I think it's a basic fairness issue under New York CPLR 3013 and 3016B. Generally speaking, if you're going to make a claim of fraud, you actually have to plead allegations so I know, as a responding party, what you're saying.
Sir.
Yes, please.
Didn't they plead unconscionability?
They did plead unconscionability.
Okay, so you could shoehorn usury and fraud under that.
Shoehorn, Your Honor?
The whole focus here is we're dealing with very unsophisticated individuals that were, from a certain point of view, hoodwinked into a scheme here.
That's a fascinating question, because the only hoodwinking done was by the guarantors of my client.
Well, we don't know that.
But you do know that
Excuse me, because, for example, in Stephen Shapiro's affidavit, he refers to Martin Braunschweig as the lawyer provided by the lender to represent us. So there are enough allegations in here to tie the lender to the broker to the attorney. And we can't ignore that, so that when you're talking about unfairness, I'm not sure where that lies.
I'm happy to address that. The problem with that allegation is, how could he possibly know that? What was the factual basis?
Well, that would be something you could ask about in Discovery Council, and that's why, one of the many reasons why discovery should have occurred here, wouldn't you say?
No.
Then you could find that out.
I will tell you why. In this particular record, there is an attorney opinion letter from Mr. Braunschweig to my clients.
Mr. Braunschweig had never met these people before he went to the closing, and never spoke to them at the closing, because one of them wasn't there, and the other one he didn't speak to. So I don't understand how Mr. Braunschweig could speak for them at all.
Wouldn't that be a legal malpractice claim, if anything, on that basis?
Or an attorney grievance claim possibly as well, but it's certainly a question that would be appropriate for discovery because it suggests that there may have been some collusion between Mr. Braunschweig and one of the other parties, don't you think?
Well, those are not parties, is the problem.
Well,
None of
except,
those
no,
people
the
are
lender's
parties.
a party.
What was that, Your Honor?
The lender is a party. Yes.
The lender's the plaintiff, right?
Yes, and that's a party with whom Mr. Braunschweig might have been in collusion based on the allegations in the papers.
I'm so glad you said that, Your Honor. As you know, on a summary judgment motion, you cannot oppose summary judgment with speculation and conclusions.
You can
And
oppose
that's
it
what
on the
is.
fact that discovery hasn't been done, which would reveal relevant facts. And
That
that's part of the claim here, isn't it?
That's also because they didn't make any discovery demands in response, and they never actually proceeded on discovery. How long should a lender in a mortgage foreclosure case in a commercial action have to wait to move for summary
This
judgment?
isn't a commercial action. This was a consumer transaction.
No, Your Honor. This is a commercial transaction.
You're saying it's a commercial transaction because of the LLC, but then we have to take one step back and talk about how this LLC was formed. Well, I think I can appreciate your arguments, but I think that there's so many things that are unknown, maybe stemming from this Jonathan person, but the relationship with him, with the attorney, and also with the lender. And that's made out in their affidavits. It might be at a later date you're successful in your claims, but we wouldn't know that because there was no discovery. There was nothing to flush out these particular issues.
I'm glad you said that, Your Honor.
I'm glad I said it too. Thank you for saying that.
I do, because I think that the party who would actually know this are the Shapiros.
How would they know the relationship between the lender and Bromschwitz and Jonathan? How would they know that?
So, for instance, Mr. Braunschweig,
One of them wasn't even at the closing.
if I may, Mr. Braunschweig is their attorney. It's a very simple phone
That's
call.
the whole issue. That's the problem. They claim that he really was not their attorney. He was told, they were told, or at least the brother who was at the closing, this is the individual who will be representing you.
Your Honors, they had the closing documents on January 31st for a February 11th closing. What claim of fraud have you ever seen where you get the documents in advance, has all the details, has the entity name on it? You know about this.
Is the attorney's, is Braunschweig's name on it as well?
Actually, I believe it was a different attorney for that originally. Yeah, there's a different attorney, and then it became Mr. Braunschweig, I believe, at the end of that transaction.
Okay.
But it's my understanding, if you read the Eric Shapiro affidavit, he went to independent counsel to review these documents, and that attorney told him he didn't have enough time, and he then proceeded on the transaction. I've done many fraud cases. I have never seen a case where you get the documents nearly 2 weeks in advance, you get the opportunity to review them, you get the opportunity to sign, you get the opportunity to decide whether you want to proceed on that.
Well, given your experience with these fraud cases, does this not smell?
It does not smell, no.
It doesn't smell.
Not to me, Your
What
Honor.
about the disbursements? Do the
Glad you asked.
disbursements smell at all? I know you're glad I asked that question, right?
I am, yes.
Every question, you're so glad we asked.
Well, I enjoy actually being here.
I know.
I love this. I love
Isn't it beautiful? But it's getting a little late. It's getting dark. So go
I
ahead.
apologize. I apologize. So the short answer is that disbursement sheet was actually provided. There's a draft copy in the record in opposition to the motion for summary judgment. They had it beforehand. They knew what the
What
disbursement
evidence is they had it beforehand? I don't remember seeing any evidence of that in the record.
In the opposition to the motion for summary judgment, they attached a number of unsigned documents they said they received, and as I recall, there's an unsigned proposed disbursement form. But also, normally, you know at the table, and that's usually when you sign on these types of transactions, this is how much we're getting. The best part of this is that the lender dispersed the funds to an account set up by either the Shapiros as directed by Mr. Braunschweig. This, what you're describing, what you're
Actually,
thinking...
that it's,
Yes,
it
Your Honor?
appears that the direction to send the funds to that account was from the lender's attorney, not from Mr. Braunschweig.
That's not correct. It's actually
It's
in the record.
That's what the record says.
No, the record shows it's a request by Mr. Braunschweig directing the specific account to MMPS. That's what the actual email shows. My clients would not care really where that was dispersed, and the parties who have control
Except for
of
the part
this.
that went back to them.
What was that, Your Honor?
Except for the part that went back to them.
The part that went back to my clients is because of the hold harmless agreement, which is dehoards the record and which ratifies.
I'm
this
not talking
transaction.
about that. I'm talking about the $7,500 fee at the beginning. I think it was $7,500.
The $7,500, Your Honor?
There was a substantial fee to your client early on.
As part of this transaction, my client-
$9,000 to your client as a commitment fee. I'm sure they were concerned about where that went.
who would be concerned about that, Your Honor?
Your client.
My client would not have done the transaction if it had been told to them that it was not going to be a commercial deal. If you look at the record here, the Shapiros admitted in their affidavits they tried to get institutional lenders, and no one would give them a loan for a variety of reasons.
Right.
Yeah, that's not because my client's a bad person. My client is the only party who actually...
Why is it so important that it was a commercial entity?
Of course. It's because they don't want to give residential loans. Residential loans are subject to all manner of prescriptions.
Of usury.
Not just
usury regulations and other related commercial regulations, correct? Isn't that why your client doesn't want to give residential loans?
My client doesn't, for that and servicing reasons, right. There's a vast area of it. If they had been told this was a residential deal, they wouldn't have funded it. The deal would have died at the table. My client would not have funded such a transaction.
Exactly.
Right. But the problem here is my clients didn't do anything, and there's no portion of this record which establishes it. And I really want to emphasize, we are talking about a motion for summary judgment with two unpled defenses where they are being raised in opposition to summary judgment for the first time. And because of that, there is no possible discovery that could have been done.
That is a very fair point. And there certainly are plenty of cases that say, we're not going to consider an unpleaded claim or defense.
Yeah.
There's also another line of authority that says we will, particularly in opposition, not to support summary judgment, but to oppose summary judgment, we will consider an unpleaded cause of action or defense, provided there's no prejudice. So were you prejudiced in one way, or was your client prejudiced in one way, shape, or form by the introduction of these heretofore unpleaded matters?
I'm glad you asked that. I apologize, but yes, I am actually glad because I
didn't get one of those yet, so I appreciate it.
Now, everyone has gotten one. We're all
welcome.
good now. Okay, go ahead.
A little distinctive on my part. So it is prejudicial to do that where these are essentially new fact issues, right? Because you're talking about facts regarding purported relationships between parties that are solely supported by the guarantor's self-serving affidavits. And that is a problem. Because if you think about it, it's an attempt to create a factual issue by submitting your own factual testimony on something you didn't raise as a defense in any kind of specific manner under New York CPLR 3013 or New York CPLR 3016B, which requires fraud to be pled, and more specifically to be pled with specificity. Because we didn't get an opportunity until the opposition for summary judgment, what possible discovery could have been done, or could we have known about a need for possible discovery to address this? And the problem is the burden on a party making an unpled defense, especially in a mortgage foreclosure case, should be higher. Because I think you have to consider the policy problem here. If every single borrower in every single mortgage foreclosure case can basically not assert a defense or assert defenses that they don't defend and then ambush and surprise a lender in opposition to summary judgment with bold and broad claims of fraud, you're creating a new problem in the record, in these types of matters, because this loophole this particular appellants are trying to create is as wide as a gate. And many, many, many borrowers are going to be here before you making the exact same claim about broad claims of fraud by Wells Fargo, Deutsche Bank, US Bank. Oh, my mortgage broker defrauded me and therefore I shouldn't have summary judgment against me in a foreclosure case. This is a huge problem because what is being asked of you is to expand a minor issue that usually has to be actually supported by real evidence into the type of amorphous, anomalous matter that will bury this court with new litigation and new appeals to handle.
I think we can deal. We'll handle it. We're good. We're good. Did you have another?
I appreciate my eloquence at least.
Thank you
very much, Your Honor.
Thank you.
These are the kinds of cases we should
Pay the big bucks.
Just very briefly, Your Honors. I think, starting with the last thing that respondent said, it's crucial to remember the posture of this case. No discovery has taken place here. So the information regarding Jonathan's relationship with the lender, Brown Trust.
Was that because he didn't serve any demands for discovery?
There were no demands served because almost immediately after the answer in this case was filed by the Shapiro brothers' prior counsel, that counsel moved to withdraw and that motion was granted. The Shapiro brothers began trying to obtain alternate counsel. However, they have very limited means. They did not have the funds to hire private counsel, and it took them over a year to get new counsel. In May of 2023, when Kasowitz made its appearance along with the Legal Aid Society, summary judgment had already been filed.
Sorry, that initial counsel they had, was that from that mortgage foreclosure
that was a
center in the Bronx, or was that they had a private lawyer, but then
that was a separate private attorney that the relationship broke down very quickly, and they moved to withdraw almost immediately after the answer was filed. Their new counsel, Kasowitz, as well as Legal Aid Society, entered appearances after summary judgment had already been filed. So the immediate urgency, I believe the Shapiro brothers were actually at risk of defaulting on that motion. So there immediately needed to be applications made for an extension of time. We needed to oppose that motion, and immediately upon opposing summary judgment, pointed out the need for discovery in this matter. No discovery then did not proceed as summary judgment was granted, judgment of foreclosure was entered, and the rest of this case followed. However, it's important to note that the facts underlying these defenses, Jonathan's relationship with the lender, et cetera, are only in the possession of these other parties. There's no way the Shapiro brothers could have the information that they would need to factually support these defenses without having taken depositions and without requesting these documents.
Yeah, but that really has a little to do with NY 2015 vote, right? With the
respondent.
Yeah, yes.
The respondent's relationship with those parties, we believe, Your Honor, is very important. Again, Braunschweig appeared at this closing as an attorney that the Shapiros were told would represent them. How he got there, who hired him, is important. Additionally, Braunschweig directed the account for the funds of $103,000. If there's a pre-existing relationship between the lender and Braunschweig, then
Well, the lender believed that Braunschweig represented the Shapiros.
is their contention, but the Shapiros don't know Braunschweig. So that's a question of fact that discovery is really necessary on. We need to figure out who hired Braunschweig. That's a key fact in this case that the Shapiros were not allowed to look into or determine.
Thank you. Thank you both.
Thank you, Your Honor.
Last but not least, Efron versus Efron.
May it please the court, my name is Ethan Brescher. I'm here on behalf of the appellant Elon Efron. Mr. Efron asks that this court reverse the Supreme Court's March 13, 2024 decision appointing a receiver to sell the party's marital residence on the grounds that it is undisputed that she signed the listing agreement by the court's October 4 deadline, and that listing agreement was rejected by Mr. Efron's counsel. We also request that the court reverse the appointment of the receiver on the basis that the August 11 stipulation is too indefinite to be enforced as a contract because it lacks a purchase price for the sale of the marital residence. And therefore, the Supreme Court erred in appointing a receiver on the grounds, as was set forth in the Supreme Court's March 13, 24 decision in order, that Ms. Efron violated the August 11th stipulation and the October 2nd order. So Ms. Efron she got a second chance by the Supreme Court, and she took advantage of it, and she honored it, and she sent through counsel the listing agreement that Mr. Efron's counsel at 3:02 p.m. on October 4, 2023 rejected. And he rejected it because he wanted a provision in the listing agreement that he was not entitled to have.
In other words, his client wanted a right of first refusal as well.
His client wanted a right of refusal. Mr. Efron's counsel wrote in his email that if by some miracle Mr. Efron came into money, he wanted the right of first refusal. And that was not in the August 11 stipulation. And so it was rejected. This is a simple matter for the court. With all due respect to my colleague, Mr. Efron's counsel, the October 2nd order was complied with, and for whatever reason, the August 11 stipulation did not have a listing price, and there's no way to determine what the listing price would be. It wasn't delegated to a broker, it wasn't delegated to an appraiser, it was subject to future negotiation. And under the Court of Appeals Cobble Hill case, I think, and other cases, there's no way to know what the listing price would be. Under these circumstances, there's no receiver should have been appointed, and the ongoing, but now stayed by this court, contempt proceeding against my client should be dismissed sua sponte by this court.
Thank you.
Good afternoon, Honorable Court. My name is James Iniguez, and I represent Mr. Efron, the respondent in this matter. I am also the attorney in the court below. To correct some matters, Mr. Efron actually did not seek, and the record was later corrected, and did not seek a right of first refusal. That was a misunderstanding between myself and prior counsel. That part of the record was not included.
Could you stick to what is in the record?
What is in the record, Your Honor, is that there's a stipulation that states that the parties will use a specific broker. That specific broker, off the record, had recommended a price which all the parties had agreed upon. It is not contained in the stipulation, but it was understood by all parties that the home would be.
It's not in the record before us, correct?
It is in the record before you, Your Honor. If you look at the transcript from the hearings that were had in terms of the contempt proceeding and the motion, it was.
But in the stipulation that was agreed upon.
The actual stipulation, that price does not appear. However,
Or in any other document before the stipulation was signed?
well, the listing agreement clearly states that it's a $2 million purchase price, which both parties had agreed to. And that was referenced in the agreement, that the stipulation, that the parties would sign the agreement as of the end of the term for her to find a loan. So that was contained within the stipulation in terms of by reference, pardon me.
So the stipulation states that it incorporates what was stated in the transcript? Or prior, prior statements or prior agreements as to the price?
Conversations had on the record as the stipulation was being signed, but were not included in this record of appeal, clearly stated that the sales price would be $2 million.
I know that you know that we're limited to what's in the record. So there's no price in the record before us.
The record before you, there is no price in the record before
Thank you.
Thank you.
If there are no other questions, I rest on the briefs.
Thank you. Thank you both.
I'm sorry. Have a good night.